So we obviously have a fantastic panel tonight. I am personally just so excited to talk with them. And I also want to say, just looking at the attendees list, it's really nice to see so many familiar faces. We've been doing this together about weekly since very shortly after quarantine. And I've said this before, but it really has been one of the highlights for me, getting your questions and interacting with you even this way. And I hope that we will all do it again at the Hammer Museums at some point. So I want to show really quickly some slides that I hope we will bring up. And obviously this is the topic du jour: can members of the Electoral College be faithless? And then if we could go to the next slide, I just want to explain to the audience where I'd like to take the conversation. First, just talking about what is the Electoral College? Why do we have it? What's its purpose? And what are these so-called faithless electors? The word faithless obviously brings a lot of things to mind. What does it mean to be an elector who's faithless? Can states prevent electors from being faithless? And really talk about these two big cases before the Supreme Court, one out of Washington State, one from Colorado State. Talk about what arguments were made on both sides, by plaintiffs who said, I want to go rogue, and by the states who said, no, you can't. And then finally, talk a little bit politically about what's the legal and political impact of the Supreme Court decision. And then one of the political scientists' favorite topics is the Electoral College here to stay. So with that, really briefly, could we see the next slide? Obviously, what we know from 2016, from 2000, is that the name of the game for the presidential campaigns and for the presidential election is the Electoral College. So you have a quick showing there. I apologize, it says 2020 electoral map. It should say 2016, and it shows the Clinton-Trump divide. And then the next screen, the next slide, shows what happened in 2000. I was clearly subconsciously trying to take 2016 out of my mind for a moment when I wrote that slide. I apologize. With that, let's bring down the slides, bring back the panelists. And Franita, could we do let's do ladies first. What is the Electoral College?
A relic of slavery, but that's too, that's probably too flippant, even though it's true, right? Because, I've been reading a lot about the Electoral College recently. Alexander Kaiser has a great book out now. And the question is very relevant to what we're talking about today. Why do we still have the Electoral College? Why do we have it? And one of the things that he points out is that it was supposed to be a temporary replica of Congress, right? The electors are supposed to assemble, they're supposed to debate, they select the president, and then they disperse. And the electors are selected by the states. Some states initially appointed electors, but then it pretty quickly turned into a situation in which electors were chosen based on the popular vote of people within the states. And interestingly enough, people have been complaining about the Electoral College for 200 years. It's one of those situations where it just seems like we can't get away from it. But with respect to my initial comment about it being a relic of slavery, the Electoral College is interesting because the southern states actually got a boost in the Electoral College because of the way congressional seats are apportioned. So electors are determined based on a state's congressional delegation. So the number of House members they have plus their 2 senators. And so the Constitution in Article 1, Section 2 provides that congressional seats are apportioned based on population, and that all other persons will count as 3/5 of a person for these purposes. So effectively, the southern states were able to count their slaves as 3/5 of a person and got the benefit of that in Congress and the apportionment of seats. And then, of course, that bled over into the Electoral College. And so the Electoral College had the effect of giving slave owners and slaveholding states outsized influence on the national stage.
That obviously is one of the consequences. And we certainly have, and I almost put up a chart, but we have a situation where, I'm voting in California on election day. And I think that people voting in Wyoming have something like 6 times the voting power to pick an elector. So Erwin, if we could go to you for even more on what did the founders say about why they wanted an electoral college? Was it meant as a safety valve to protect us from ourselves, that these elder statesmen would come in and make sure that we don't pick an uneducated demagogue, or what else was there behind the scenes?
The answer to your question is yes, but let me start by saying how wonderful it is to be part of this program with you and Franita. The framers of the Constitution were deeply distrustful of majority rule. Think of the government that they created. The president is chosen by the Electoral College, and as Franita said, initially in many states, the electors were picked by state legislatures, not by popular vote. The Senate was chosen by state legislatures, not by popular vote. The courts are nominated by the president. Only the House of Representatives, one of the four institutions created by the Constitution, was chosen by the people. And in fact, if you look at Hamilton's Federalist number 68, he specifically praises the Electoral College because he says we should have the enlightened individuals choosing the president, not leaving it to the masses. But I don't think we should forget what Franita said either. Slavery was a key part of it. In fact, at the Constitutional Convention, James Madison from Virginia, Hugh Williamson from North Carolina, both talked about the importance of the Electoral College in making sure that Southern states would be able to have their slaves counted as part of the political representation. It was also meant to help smaller states. The Senate gives every state, regardless of size, 2 senators. And the number of electors that a state gets is the sum of its senators and its representatives. So that's why Wyoming, that has 2 senators and 1 representative, end up with a statistical benefit compared to a larger state like California.
Yeah, I mean, it does feel for people in California, obviously, I think a little strange that your cousin voting in Wyoming on the same day has what, 6.7, 6.8% kind of. Franita, has the Electoral College ever worked the way that maybe was intended, in the sense that if it was meant as a safety valve to protect us from ourselves, have the electors ever said, no, I know people that you voted for this presidential candidate, but in fact, we think you've made an unwise decision? I mean, have they ever saved us from ourselves?
No. So the vote of a faithless elector has never been dispositive in a presidential election. Like I think something like it's been 180 faithless electoral college votes out of 23,000 or some number like, and it's never determined the outcome of an election. The question of whether or not the Electoral College whether or not it has actually worked the way that the founders intended is an interesting one, and I can't wait to hear Erwin's answer on this, because my sense is that it has, but in ways that they didn't expect. So consistent with Erwin's point about the founders being concerned about majority rule, there's this safety valve in the Electoral College, right? If no candidate gets a majority of the Electoral College votes, it goes to the House of Representatives, where that body will, each state's delegation gets 1 vote. That body chooses, who the president will be. I think that was viewed as a way of protecting it against, a president who is a demagogue, right? And that actually happened twice in 1800 and 1824. But it was a nightmare, right? No, it actually, 1800, 1824. No, that's right. So 2. And it was a nightmare, right? It was this completely politically polarized, horrible situation in which it was clear that the Electoral College was not the solution. But I'm hard pressed to say that wasn't in accordance with what the founders thought would happen, or sort of they viewed that as a good thing, but when it played out in practice, it ended up being a bad thing.
Right. So they may have intended consequences that we may now not think are, I'm sorry, Erwin, please.
Exactly. Yeah.
I find it not very helpful to think about what would the framers have thought about the world that we live in today. Let's start with the fact that the framers didn't think there should be political parties, and they didn't anticipate political parties would happen. Of course, they developed relatively early in American history, and political parties are so key to how the Electoral College functions. They didn't expect suffrage in the way that we think of it today. They wanted white men who own property to be able to vote. We all know that women didn't get the right to vote till 1920. And with regard to African Americans, the 15th Amendment, 1870, was supposed to provide protection of the right to vote, but we know that there was massive disenfranchisement of African Americans, at least until the Voting Rights Act, and it continues today. So it's very hard to say, what would the framers in 1787 have thought about our modern world? Because we can't possibly know.
Yeah, I mean, that's true. So let's come to current times, which may be no more or less scary. But Franita, what do we think about, this is a unfairly broad question, but what do we think about the Electoral College on the whole, regardless of what the founders wanted? Is it serving good purposes? Does it have good policy outcomes? Or is it actually doing more harm than good?
I think it does more harm than good, in a sense. But it really depends on what you care about, right? If you think that the president is supposed to be elected through popular majorities, then I think that the Electoral College is clearly counter-majoritarian, right? A lot of states have winner take all, where and in fact it might be most states, except I think Maine and Nebraska allocates 2 electors statewide, and then they allocate it based on winner of the congressional district, right? But 48 states have winner take all, where you don't have to win a majority of the votes. You just have to get more than your opponents, right? And so you can end up with a situation where, and we have, right, where the winner of the Electoral College has actually lost the popular vote. And so if you think about how it operates today, it is really counter-majoritarian. And then with respect to the safety valve, where it goes to the House of Representatives, if no one reaches 270, if if it was determined today, states representing less than 20% of the U.S. population would decide the next president, right? Which is, I mean, it's horrible to think about, but it's the system that we have. And so I would say that it's not really working. Now, of course, if we say it's not really working, I'm sure we'll talk about this. What do you replace it with? But I think it's enough. We can all agree that it probably isn't working.
Erwin, a compound question. Is there anything that we would like to keep about the Electoral College, and what would we replace it with?
No, there's nothing we should keep about the Electoral College. It's inconceivable that a democracy should have someone chosen as president who loses the popular vote. It's happened 5 times in American history: in 1824, 1876, 1888, 2000, and 2016. There's no other country in the world which has a democracy, and yet the loser of the popular vote becomes president. I actually believe the Electoral College is unconstitutional, and it would seem strange to say that a part of the Constitution is unconstitutional, but here's my argument. The text of the Constitution is modified by the amendments. The 5th Amendment is interpreted to include a requirement for equal protection, and the Electoral College violates the requirement for equal protection. Now, I don't think any court is going to declare that unconstitutional, but Franita rightly points to another key problem, and that's winner take all. She says in 48 out of 50 states, whoever wins the popular vote gets 100% of the electoral vote from that state. So if you vote for Donald Trump in California, your vote is meaningless for the Electoral College. If you vote for Joe Biden in a red state that's carried by Donald Trump, your vote is meaningless. So I think, if nothing else, winner take all should be declared unconstitutional. What would I replace it with? National popular vote for the president. We should choose the president the same way we choose the governor, the same way we choose a mayor. Whoever wins the popular vote should be the president of the United States.
Now, do states have to have a winner take all situation? Obviously, Maine and Nebraska don't. Could California just wake up and say, you know what, we'd like to go the way of Maine and Nebraska?
Sure, any state could. The Constitution lets each state decide how to choose its electors for the Electoral College. If a state wants to do winner take all like 48 states do, it can. If it wants to allocate in some other way like Maine and Nebraska, it can. But of course, there is a concern for any given state about engaging in unilateral disarmament.
Right.
Why would California, a blue state, want to split its electors unless, say, Texas, which has been a red state, wants to do that too?
Yeah, I mean, it makes me think of the, oh, I don't want to be the beneficiary of a super PAC, but I can't say no because everybody else is the beneficiary of a super PAC. So I'm just going to wait it out, and therefore there will be no political will. And this is kind of the conversation around why don't states move to away from winner take all, because it would solve some of the problems.
Right.
Franita, did you want to jump in?
Well, I was thinking that, states could adopt ranked choice voting. Ned Foley has a great book out where he talks about ranked choice voting in this context, and then we'll get rid of the winner take all problem because voters can rank their choices. And if no candidate wins a majority, then the candidate with the fewest votes will drop off. The votes are then readjusted, and then voters who pick the losing candidate, their vote is reallocated to their second choice. Then the process repeats until you have a majority. Right. And so that makes it less likely that you have this disconnect between the Electoral College winner and the popular vote winner. So, I mean, there are like proposals floated out there that you can have without a constitutional amendment.
So let's say we use the nuclear option. So a couple of options are states say we're not doing winner take all. States say we're doing ranked choice. Things that don't require, as I understand it, a change to the Constitution. Let's talk about the nuclear option, Franita, that does require a change to the Constitution. Erwin said, I like the national popular vote. Now, can you rain on his parade just a little bit?
Do I have to, or can I?
No, you don't. I can fulfill the role I always fulfill on these forums, which is I can be the rain on the parade and you can continue to be the sunshine. If you
Well, I can rain on someone's parade, but I think people in the audience might hate me for this. I wonder about the constitutionality of the National Popular Vote Initiative. And so I think that if we constitutionalize that, it would solve a lot of problems. Or we could just simply constitutionalize a national popular vote. But so I guess I'm raining on someone's parade in the sense of questioning the constitutionality of what has proven to be one of the most promising changes to the Electoral College that's currently proposed. So for people in the audience, the National Popular Vote Interstate Compact is a compact of states that agree that their Electoral College votes will go to the winner of the popular vote. Right now, the number of states signed on, I think it's 15 or 16, but it amounts to about 190 Electoral College votes. And, there are some questions about the constitutionality of the compact, even though, it is definitely a step in the right direction. And so it is a way of trying to get a national popular vote, but trying to go around the Electoral College without constitutional amendment.
Erwin, last question before we get to the cases. I live in a small state. I would prefer that the candidates not totally ignore me. There aren't that many people who live in my state, but I think that my views should be heard. And if we have a national popular vote, all those candidates are just going to be in LA and New York and Chicago, and I'll never be able to reach them or see them. Why should I be punished just because of where I live? Is there any response to that?
Of course there is. The candidates are going to spend time and money on advertising in some places and not others. In California this October, we're not going to see ads for Donald Trump or Joe Biden because everybody knows how it's going to come out. On the other hand, if you live in Ohio, you're going to see a lot of ads for both Biden and for Trump. So the candidates are already making choices about where to spend their advertising money. But we also live in a world of national media where we see the candidates and the candidates hear from us all across the country. And so a vote in Wyoming should matter just as much as a vote in California as a vote in New York. That's what eliminating the Electoral College would be. All our votes would be equal, not weighting some more than others.
I lied. Franita, last question before we get to the case.
Okay.
Will the national popular vote have if we move to that, would it make campaigning more expensive? Would it actually say we need to increase the amount of money that it takes to run for office?
I don't know. The current system, I mean, it basically takes $1 billion to run for president, right? So will it possibly get worse? Maybe, but things are already pretty bad. So I think for that reason, it's less of a concern. It's hard to know without living under that system. You could have a situation in which the focus shifts, right? So right now we focus on swing states, the states necessary to get 1 to 270. In the future, it might be some different combination of states under a national popular vote plan. So it's kind of hard to say, but it's already so expensive to run for president. Eventually, you get to a place where the dollar just has, I mean, it can only do so much.
Yeah, and right now we spend, as you said, so much money, but if you look at it per voter, people say, well, that's not that much. And there are all those arguments. Well, you spend more on yogurt, you spend more on cereal. But as you point out, that's totally, that's a kind of worthless comparison, because we're spending that money for the swing voters in the swing states. And so we're spending, $10 a vote, I think even more. Now, let's get closer to the case. Who are, Erwin, who are electors? We know that they are not appointed by the state legislators anymore. Are they party faithful? They're popularly elected?
Every state has its own system for choosing electors. Many states have state conventions that do that. California has a system where office holders and the candidates choose who will be the electors from California. The key is, under the Constitution, each state decides who its electors will be.
And Franita, as you told us in the beginning, they don't often go rogue. That there are very few, I think you said 180 instances over all of the votes. Now, why do so many states have these laws that say you have to be faithful then?
Well, so for a long time, states had pledge requirements where the electors would pledge to vote in accordance with the party's wishes. And then we got to a point where states started adopting laws where they would fine electors for going rogue or remove them altogether. And so really you have, and I wouldn't even say that it's new in a sense that if you look at the majority opinion, one of the things that Justice Kagan, who writes for the majority in the Faithless elector case, one of the things she talks about is that this is essentially longstanding practice, right? That the electors have been pledging to support their party's candidates since early in the 19th century. And so states, I think, in some ways just kind of formalize what was a longstanding practice.
Erwin, let's dive into the case.
Sure.
Who were the two plaintiffs, and what were each one of them arguing respectively?
Peter Ciaffolo was an elector in Washington State. He wanted to try to persuade Donald Trump electors to abandon voting for Donald Trump by not voting for Hillary Clinton. Washington has a law that says that if an elector doesn't vote in the way the state directs, it's a $1,000 fine. He was fined, he and a few other people, there were two others, were fined for not voting in accord with the results of the Washington state election. And he challenged this fine in state court, and ultimately that made its way to the Supreme Court. The other case came from Colorado, which is a different kind of law. It says that if an elector is not going to vote the way the state dictates, the state will simply replace that elector with somebody who will vote that way. And in this instance, Polly Baca brought a challenge seeking an injunction against enforcement of the Colorado law. So there's 32 states that have laws that say that electors have to vote in the way that the state dictates. How they enforce it is different, and you see that in Washington enforcing it by a fine, Colorado enforcing it by removal, but they're all about dealing with this problem of the faithless elector.
Different flavors of the same idea. So, Franita, it seemed to me that in the Supreme Court, in the two cases, there were kind of two different arguments that were being made from the two different sides of the same coin. And can you walk us through a little bit of what the states were arguing? Legally speaking, why did they say we have the power to do this? We have the power to remove or to fine? So
Article 2 gives states the authority to appoint the electors, and the court has interpreted this authority to be very broad. And if you look at the opinion, what the states are essentially arguing is a greater includes the lesser argument to some extent, right? If they have the power to appoint, then they can condition the terms of appointment. So here, because they have the power to appoint the electors, they also have the power to impose substantive limitations on what the electors can do, including by fining them or removing them for failing to vote in accordance with the party's wishes.
Erwin, what about the electors who said, well, I'm not a rubber stamp, I'm a person. I have an individual right, and you can't trample on that state.
That was the argument that the electors made. In fact, they presented it as a First Amendment claim. They said that to force them to vote a way that they didn't believe in infringed their freedom of speech. They also said that this violates the Constitution, that the 12th Amendment, which determines how we select the president, gave to the individual electors the ability to vote the way they wanted.
Erwin, a question that I never envisioned asking you, how does Frodo Baggins play into these cases? Or Franita, isn't this a question that Justice Thomas asked during oral arguments? So,
Sorry, you got me there, Jessica.
I listened to the oral argument too, and it's amazing what we focus on.
So I think at one moment, and I might be having a complete brain freeze, that Justice Clarence Thomas, who, as we know, Erwin, how often does he ask questions?
Well, prior to the telephonic arguments in May, not once all this year, and he often goes years without a question, but he participated in all of the 10 cases where the justice got to ask questions in sequence through the telephone.
So there was this moment where they were arguing the cases, and Chief Justice John Roberts turns it over to Justice Clarence Thomas. And I'm thinking there's going to be this awkward pause, or there'll just be, a simple pass. And suddenly there's Justice Clarence Thomas asking questions like it's no small thing. And I believe that one of the questions in these arguments, this is why I was asking, and we should have talked about this before, I apologize, was that he said, well, what limits can states place? Couldn't you vote for a Frodo Baggins? Couldn't you vote for a fictional character? And he was really involved in a way that, I'd love to ask you this at the end, how you think that the oral arguments over the telephone changed it. But for me, it was just a revelation to hear him participate that much.
Yeah, and if you think about it, the question makes a lot of sense in the context of his concurring opinion. Like, he agreed that states can condition it, but he claimed that it was based on the 10th Amendment and not Article 2, because he didn't want Article 2 to be read as a grant of authority to the states in this way, right? Because he thought that the reference to the use of the word manner in Article 2 suggested that states can just appoint, right? They can appoint the manner of appointing electors, and that's all they can do. But if you read manner as having a substantive component, then that affects how we read manner in the rest of the Constitution, right? Article 1, Section 4 gives states control over the time, places, and manner of elections, right? If we read manner broadly in Article 2, that means we're also positioning ourselves to read it broadly in the rest of the Constitution, right? So he's pushing back against this idea that states have substantive authority under Article 2.
Yes, and Christy Pace, you just posted in the chat. I appreciate it. A New York Post article, Clarence Thomas name drops Frodo Baggins. This, awesome. By the way, what I had for breakfast, who's to say? Which classes I'm teaching next semester, can't remember. That one insignificant moment, that, however, will stick with me. So Erwin, Franita previewed the concurrence a little bit. Could you tell us about the majority? Was this a divided decision? Was the court fairly consistent in its view?
It was a unanimous result. Justice Kagan wrote the opinion for the court, and she said that Article 2 of the Constitution gives to each state the ability to choose its electors. If a state wants to therefore say, in order to be an elector, you have to vote a particular way, the state is allowed to do that. It says there's nothing in the Constitution that prohibits a state from dictating an electoral vote. She said longstanding practice matters in interpreting the Constitution. And she said the longstanding practice has been that states can prescribe how electors vote. Said earlier Supreme Court decisions had approved states defining how electors vote. That then means in the context of the Washington case Chiafalo, a state can fine an elector who doesn't vote according to the state's dictates. It means in the context of the Colorado case, Baca, that a state can remove an elector who doesn't vote the way the state wants.
And I was actually, Erwin, I was surprised to see a unanimous decision. Were you after oral arguments or no?
It's interesting. I listened to the oral arguments in the case and I missed the Fredo Baggins. It's amazing what goes past somebody. I wasn't at all surprised after the oral argument. After the argument, it seemed really clear that the justices had the position that states are able to do this. Now, predicting cases based on oral arguments is often like reading tea leaves. I have often predicted wrong based on the oral arguments, but in this instance, my intuition was that the justices were going to rule in favor of the states, and they did.
And honestly, it's the chaos principle, right? In the sense that what would the world look like if, if states were not permitted to fine or remove faithless electors, right? There's always this concern about ensuing chaos in a system that's already chaotic. So I do think that there was some of that made the results somewhat predictable.
Franita, could you expand on that? That was something I wanted to talk about. There was a lot of discussion about what happens if the court votes in a contrary way. What happens if the court says, no, states, you can't impose these loyalty laws. Faithless states lack the power on the one hand, and or faithless electors have the individual right that they aren't just rubber stamps, that they can exercise some discretion. So what specifically was the chaos that the court was worried about?
So let me start from this premise. I think that if the decision would have come out differently, the court would have also had to tell a different narrative, right? In the opinion as written, you really do have this narrative about the electors as intermediaries, right? They are supposed to convey popular sentiment. This is why states can force them to vote in accordance with who has won the popular vote, right? If the case would have come out differently, that would have required a different narrative. A plausible narrative, though, interestingly enough. So the story would have been sort of, these are Hamiltonian electors, right? They are individuals, they have independent judgment, they can deliberate, they can decide. And if they decide contrary to what the public wants, it's in the public good to do so. And this is actually not that unusual. For a long time in American history, property ownership was considered an indicator of someone who has independent judgment, right? Voters are also referred to as electors. Regular, everyday, ordinary voters. And so for Kagan to write the opinion in a way that emphasizes how much we've gotten away from that, in order to come to a contrary result, I think the narrative would have had to change. But I do think that if states could not police electors in this way, it's possible nothing happens. Keep in mind that we've only had 180 faithless electors in our history. Also keep in mind that we live in a time of high political polarization. And so that means that, the party faithful are likely to vote with the party and who the party prefers. So some of this could be controlled by ordinary politics. But on the other hand, you could have an increase in the number of faithless electors, if states are prevented from policing this in that way. I'm not sure we would ever get to the point, though, where we would have a number of electors sufficient to change the outcome of a presidential election.
Yeah, Erwin, the argument was that we were going to hit this kind of nightmare scenario and we would be bribing electors. And I guess that hasn't happened thus far, and not every state has these laws.
Yeah, I don't think it's about bribing electors. There's obviously laws that would prohibit bribery. But I think there is the possibility of a very close election in the Electoral College, and then there being enough faithless electors that they decide the result. Is it likely? I think I agree with Franita. It's unlikely. Is it possible? Sure, it's possible. And I think what ultimately this is about is a basic question. Are electors independent who have First Amendment rights to vote however they want? Or are electors just agents of the state who have to vote the way the state dictates? And the Supreme Court said, if a state wants to make it the latter, the state can do so. Now, a state could conceivably allow for faithless electors and choose the former, but Colorado and Washington chose the latter approach, saying an elector is just an agent of the state and has to vote the way the state wants. The Supreme Court said that's constitutional.
I think that's such an important point, which I read a couple of headlines that seem to misstate it, which is if a state says, fine by us if you want to vote for whoever you want, that's constitutional. It's just that states also have the power to say, no, you can't do that. And
Right.
I think that, for me, got lost in a little bit of the post-game reporting. Franita, what else, before I move on to impact, is there anything else I missed about the details of the case that I should be asking for the audience?
Well, one of the interesting things for me, I've been thinking a lot about political parties. And, one of the things we often say that the Constitution is a document that doesn't really envision parties. But in sort of thinking about this case, I'm not so sure that's true after the 12th Amendment, right? It really seems like the 12th Amendment, which changed how presidential voting works with the electors and making a separate ballot for president and vice president. I mean, Kagan makes the point that it makes it easier to have party line votes, right? Just by virtue of having the separate ballots. And that way you won't have a situation like you had in 1800 where you had a tie between Jefferson and Burr. And so, one thing that's interesting about this opinion is that we have an opinion that talks about the Constitution in a way that envisions party when the longstanding position with the courts and in legal scholarship is that parties are extra constitutional. And so I think it invites a rethinking of how we view the constitutional status of political parties.
Erwin, I know you think a lot about that as well. Are we going to have a reevaluation of political parties and how they're viewed under the Constitution?
I don't see it happening, at least not in the short term. There's no necessary reason under the Constitution it had to come to two political parties. Many other countries have multiple political parties, and yet we have two political parties. Occasionally, there's been a serious third-party candidate. I guess Ross Perot, Ralph Nader, who I think decided the 2000 election, would be an example of that. But the two-party system seems deeply entrenched. And of course, if we have multiple parties in presidential elections, it increases the likelihood that no candidate will get a majority in the Electoral College. In the case, the election would then be decided by the House of Representatives. And if it goes to the House of Representatives under the Constitution, each state gets one vote in the House, regardless of its size. So I think there's real disadvantages to a two-party system, but in the Electoral College, it may be much better than a multi-party system.
I think that's worth emphasizing given the news, which is that if the election goes to the House of Representatives, each state gets one vote. It is not that the entire House votes. And, things that I didn't think that we would have to emphasize on August 4th, 2020, but I think we certainly should. Erwin, does this decision mean the Electoral College is here to stay, or does it not really say anything about the strength of the Electoral College?
It doesn't say anything about whether the Electoral College is here to stay. The reason the Electoral College is here to stay is because it would take a constitutional amendment to eliminate it. A constitutional amendment has to be adopted by 2/3 of both houses of Congress, which conceivably would happen, but not likely. But then it has to be ratified by 3/4 of the states, and that's not going to happen. The smaller states that benefit from the Electoral College aren't going to vote to eliminate it. Now, what Franita said is maybe there'll be a compact among the states, the National Popular Vote Compact, where enough states will say, we'll give our electors to whoever wins the popular vote. That would, in essence, make the Electoral College irrelevant. But to this point, as she points out, only a small minority of states have passed it, and they're all blue states that have done so.
Right.
Red states aren't likely to do so, and they think they're more likely to win in the Electoral College. There's also constitutional questions whether this could be done by a compact. And there's also issues that would be enforceable. What if a state says, yeah, we ratified the compact, but we're going to decide the election by giving the votes this way? So I think the Electoral College, for better or worse, and I think it's much worse, is here to stay.
Sorry, I think that was my internet for a second. I apologize. Living our 2020 nightmare of not hearing you for a moment. So this is, as Claudia said, this is our last hammer form on the big Supreme Court cases. And Erwin, let's stay with you for a minute if you don't mind. It's an unfair question because it's so general, but what should we as audience members take away from this term? And let's start with this case. I mean, what does the case tell us about the term? Is it emblematic of the term? And, what do we take away from the Supreme Court's big decisions this year?
I think this case was not emblematic. I think it was atypical. It was unanimous. The just perceived it as an easy question. I think what we should take away from this term is how much it's really the John Roberts court. John Roberts voted in the majority 97% of the time. He dissented only twice all term. Also, when the Chief Justice in the majority, the Chief Justice assigns who writes the opinion. John Roberts assigned to himself writing so many of the most important opinions of the term. We knew when Anthony Kennedy stepped down that Roberts would be ideologically the median justice, the swing justice. He's conservative, but occasionally sides with the liberals. Here's an interesting statistic. There were 14 5-4 decisions. In 10 of the 14, the majority was Roberts, Thomas, Alito, Gorsuch, and Kavanaugh. In 2 of the 14, it was Roberts, Ginsburg, Breyer, Sinner, and Kagan. I think that shows us where the ideology of the Roberts Court is overall.
Franita, same question to you.
That's a tough question
Sure.
for me. I've kind of been in a space where, and oddly enough, me and Erwin, we did a podcast earlier where someone made a point that I think captures what I've been feeling about this court recently. I'm going to say that the courts will not save you. They will not save us, right? And more specifically, they won't save our democracy. And so I think this case is atypical for that reason, because once you put it in the context of the other voting rights decisions that the court has issued this term, and most of them are just orders and but things that the court has done in the COVID era, which suggests that they are not, they're not really focused on broadly protecting the right to vote. It's so interesting to contrast that with this decision where the court talks about, electors as intermediaries for popular sentiment, and they talk about the importance of majoritarianism. But then you have other decisions that are not quite protective of the right to vote as they should be. And so in many ways, I guess that, the broader lesson for me is that to protect our democracy, we have to look beyond the courts, even if we occasionally get decisions out of the court that make constitutional sense, right? That are, good, solid decisions. The court is not sort of the repository for voting rights and democracy that, it used to be.
Yeah, I mean, if we looked at, and this was a great point, if we look at some of the COVID related voting rights decisions that either the Supreme Court has made or other courts have made, I think that the takeaway has to be the justices are not going to fly in on capes and save us.
Can I interrupt there?
Yes.
I think I agree with both of you, but where I disagree is we need the courts to do that. Take, for example, the Wisconsin voting case. What the federal district court there said was, in light of the need for absentee ballots and the delay in processing and delivering them, we need to extend the time for them to be received by a week. I think that we needed the court to do that. Unfortunately, the Supreme Court there said 5-4 that the district court acted improperly. Or take the problem of partisan gerrymandering, where the political party that controls the legislature draws election districts to benefit that party. We need the court to save us because the political process isn't going to fix itself. Or take the problem of disenfranchisement of voters of color. We can't rely on the political process to deal with that. We need the courts to save us. So I agree that this court is not going to do so. John Roberts and the other conservatives are not protectors of voting rights. But what I want to say is we need the court to do that.
Oh, no, I don't disagree with that. I'm not anti-court, right? I just recognize that recently the court has done more harm than good. And so what that does is it forces a change in strategy. It doesn't mean that people shouldn't continue to litigate, right? There is, 130 voting COVID-related cases pending in like 38 states or something. I mean, there's a crazy amount of litigation to make sure that people can effectively vote in November. That should happen, right? But I think the question has to become, what else can we do in addition to that to protect our democracy and to protect the right to vote? because the reality is that, it's likely that the courts are lost for a generation or so because of, appointees not really believing in broad access to the ballot. And so, but I'm not anti-court. I don't mean to suggest that, but just sort of this realistic view of the world where it has to be the courts plus other things.
We agree.
Franita, you served this one up to me. What are the other things?
So, power sees nothing without a demand, right? The demonstrations that are happening all over the country in response to the unfortunate murder of George Floyd really do indicate how political movements, voting at the ballot, voting in elections and litigation can work together in order to really effectuate social change. So one thing that made me extremely happy in the last few months is that Ferguson, Missouri elected a Black woman, and that wouldn't have come without sort of the activism that you saw in the streets and also people voting at the ballot box. And so it really is this relationship between all of these different things in order to move the ball forward. Whereas before, I think we were, at least, advocates and litigators were focused on trying to effectuate change through the courts. And we viewed that as our holy grail. I think it has to be less of that until we get to a position where we get some favorable precedents.
Erwin, you mentioned 3 decisions that I find disturbing: the Wisconsin voting decision about absentee ballots, the partisan gerrymandering decision, where it seems to me that the court abdicated responsibility, the voter disenfranchisement decisions. I think we could throw in Shelby County, the Voting Rights Act decision. I'm just curious for your take on, are these decisions by jurists who just have a different legal ideology, or are these decisions by jurists who want to get to a specific political outcome, or somewhere in the middle?
It's always hard to guess as to motivation, but I think right now in the country, there's 2 very different perspectives with regard to elections held by Republicans and Democrats. Republicans perceive that there is a significant problem with regard to voter fraud. The president is constantly articulating this. Democrats would say that we have a huge problem with regard to disenfranchisement, especially of minority voters. And those are very different worldviews to start from. So when you come to something like voter ID, Republicans would say, well, we need voter ID to prevent voter fraud. Democrats would say there's no proven problem of voter fraud in the country. The real problem is this is going to keep people of color from being able to vote. Shelby County, John Roberts essentially said, race discrimination in voting is a thing of the past. Ruth Bader Ginsburg in dissent says, race discrimination in voting is present, and it's present in every election, and we need to deal with it. Now, is it coincidental that Republicans believe that they're better off with less people voting, and Democrats believe they're better off with more people voting, and the Republican appointed justices take the former position, and the Democratic appointed justices take the latter position? Doesn't it all start to seem like Bush versus Gore all over again?
Yes, I was hoping you would exacerbate my insomnia, and there you truly have in so many ways. And so now I'm reticent to ask my last question before we get to the Q&A, but and Franita, maybe you want to start, but I think a lot of our audience members are probably thinking about the 2020 election, and they logged on because they're wondering about basically what could happen. So a couple of questions. Can the president postpone the date of the election? And what can he do to, for lack of a better legal term, screw with the election?
So he can't. He cannot postpone it as set by statute, but that does not mean he cannot do some things that can cause some serious problems. So, for example, it is likely that we won't know on election night who the winner is. A lot of voting will take place by mail. It takes a while to count votes that are cast by mail. And so the question is, what can the president do between sort of election night and when we actually find out who the winner is? And he can do a lot of what he's doing now, and it could cause serious problems with undermining the legitimacy of the election. He can go on Twitter, he can go on Facebook, and he can allege that there's significant voter fraud. He can say that there's especially voter fraud by voting by mail. So he's doing that now, and some people are starting to question whether or not they should vote by mail because they're sort of following him on social media. And then he can also do it after the election in order to call into question the outcome of the election. So if he loses, then he can say he lost because of massive voter fraud. But if he wins, he can say, hey, I won despite the fact that there was massive voter fraud. So technically it's win-win for him. And so for me, the big question is the president's hardcore supporters. How do they react if he loses the election? And I think that's what keeps me up at night.
Yeah, for me, that's one of the 17 things that keeps me up at night. Erwin, how would, we mention this, but let's end with this before the Q&A, I think. How would the House of Representatives end up getting the election? I just want to be clear on the mechanism for how that could take place.
Well, the mechanism that we talked about before is if neither candidate gets a majority in the Electoral College, then it's left with the House of Representatives to decide. But with only 2 candidates likely to get votes from states, someone will get a majority in the Electoral College. That won't happen. Now, there's also the possibility of disputes in a state as to who gets the electors, who will then, that could go to the House of Representatives. Again, it doesn't seem likely, but it's possible that that could happen. One of the things that we haven't talked about is we're in the midst of a pandemic, and there's going to be a real need for federal courts to be flexible in trying to facilitate the ability of people to vote. And what the Supreme Court has said is it doesn't want the federal courts changing the rules of the election before the election. That's going to really limit the ability of the judiciary to protect the right to vote in the midst of a pandemic. And so I worry a great deal about that.
Yeah, absolutely. And you mentioned some things that, and I don't know where my question's going with this, but you mentioned, that people look at things like voter fraud in different ways, that people look at race discrimination. But it seems to me that these aren't really ideological disagreements. The voter fraud just doesn't exist on a widespread scale. Race discrimination just does exist. And so you pointed out, I think what's exactly right, that we start from a different worldview, but it seems to me that we're not all starting with the facts. And that is something that concerns me as we go into what will be a very litigious election cycle, I think.
Courts don't necessarily have to, I'm sorry, Erwin, go ahead.
No, please.
No, I was going to say courts don't necessarily have to reconcile those two worldviews, right? If a state wants to adopt a restriction on the right to vote, they should have to prove it. The problem is that the system doesn't require them to do that, right? The courts are applying this balancing test that is basically very deferential to the states. And because they don't have to prove it, they don't have to actually prove the existence of fraud in order to adopt a voter ID law, then they can adopt a number of restrictions that have the effect of disenfranchising people. So if they had to prove it, it wouldn't matter if fraud exists or not. It wouldn't matter if people are disenfranchised or not. It would come down to the facts.
Erwin, did you want to say something in response? Or?
I agree very much with that. I obviously am in total agreement with the perspective that you articulated, that voter fraud is minimal in this country. Study after study shows that, whereas race discrimination in voting is still unfortunately prevalent and has been throughout American history. But there is a majority of the justices on the court and a political party that has a very different perspective, and a president of the United States who is constantly on Twitter espousing that. So, we're here today, and it's hard to know what issues are going to be litigated in October and November, but they're sure to be litigated. And what really worries me is, how are we going to protect the right to vote in the midst of a pandemic?
Yeah, Hammer audience members, I promise we're not going to end on this. We're going to transition to your questions. We will give you some optimism, or at least some reason not to refill your Xanax prescriptions. So with that, let's start it off with the Q&A. Franita, you got a shout out for explaining the a fuller history of the Electoral College. And it wasn't a question, but it was a many thanks to you. So I just wanted to read that. Ruth, thank you for that. And next question, Robert, I asked a question for Erwin, and I think I know the answer, but are some of your arguments against the Electoral College, could they also be made against having a US Senate?
Yes, I think the idea of 2 senators per state, regardless of the size of the state, is inconsistent with the very notion of 1 person, 1 vote. I think there's an argument that this denies equal protection. I don't think any court's going to declare the Senate unconstitutional. I don't think any court's going to declare the Electoral College unconstitutional. But we should recognize how much the structure that was created is inconsistent with our current notions of equal protection.
I just love the idea on an intellectual level of the Electoral College in the Constitution being unconstitutional.
Slavery is in the Constitution in many provisions, and it was made unconstitutional by the 13th Amendment. Or I'll give you another example. Congress has the power under Article 1 of the Constitution to regulate commerce among the states. That would give it the power to license newspapers, but the First Amendment would make that unconstitutional. So something that's authorized in the Constitution can be made unconstitutional by an amendment. Now, I think a more realistic argument from my side would be to say that winner take all is unconstitutional because, as we said, that's by state law. That's not in the Constitution itself.
A new question. Franita, let's go to you. This is from Deborah. Are you concerned with let's do it one more time, ballot tampering in the new voting machines? Can we trust the new machines? And according to some newspapers, there are Ivanka Trump voting machines. Sorry, I can't follow the last part, are being delivered to Georgia and Florida. So let's take it as a broader question of, can we trust the voting machines? And I'll add to that, where are we most worried about potential breakdowns?
So the second part is actually easier to answer than the first. It's going to be in places where they had problems in the primaries, obviously. So Georgia will be another. Georgia will be an example again. It'll probably be problems in Florida because Florida is always our favorite, like, poster child for screwing up in presidential elections. Wisconsin will probably have problems. Like, the primaries were a pretty good window into things that can go wrong in November. And in my view, there hasn't been enough movement to try to fix some of those issues. And so I think that in November, we'll have similar issues. But in terms of trusting voting machines and sort of the process of how the votes are cast, interestingly enough, I think that we attribute the partisanship and polarization of secretaries of states to sort of the rank and file election administrators. And I have found that not to be the case. They really just want to get it right. So the people who are running the elections at the county level, the people who are operating as poll workers, I don't think that we should sort of take the partisanship of elected officials. So it's already screwed up that our secretaries of states run elections, because then you often have situations where a secretary of state is running for another office, then they are overseeing their own election, and it just becomes weird, right? But when we talk about the everyday people who are administering our elections, I don't feel comfortable attributing that level of partisanship to them. A lot of them, they just want to get it right? They care about coming to the right outcome, and they are not so focused on, sort of promoting a certain partisan view of the world. And sorry, that was my dog in my doorbell.
We originally had a unofficial hammer form rule that if we hear a dog or child, we have to see them on video, but I won't force you to do that. I did notice Erwin closing the door, so we can't meet your dog, I think.
That was my dog that I closed the door when his dog was barking.
I think the first virtual hammer form, I started with, where are you and what or who are you most worried about interrupting this conversation? So Erwin, Perry asked a good question, which is, isn't the case in the state loyalty laws that impose a fine as opposed to just replacing the faithless elector, isn't it the case that the fine doesn't prevent a faithless elector from in fact being faithless, it just punishes that elector?
That's correct. And so the hope of the state is that by outlawing somebody voting in a way different than the state directs and fining them, that the electors will follow the state's wishes. But if all a state does is say there's a fine, somebody could say, hey, it's worth paying the $1,000 to be making the candidate I want into the president. One of the things that we said earlier may require more elaboration. Franita rightly pointed out there's rarely been faithless electors, and that's because the party in the state, one way or another, is choosing who the electors are. In California, the Democratic office holders and the Democratic candidate are choosing who are going to be the electors from California. That makes it unlikely there's going to be the faithless elector. But the question is right. In a state that just has a fine, it's certainly possible.
Yeah, great question. Franita, Matt asks, any comments about what's happening with the USPS as it relates to the election, meaning the United States Postal Service?
I am so shocked that this story isn't getting more coverage, right? So there are already reports that, mail delivery is taking, weeks longer than it normally would. And so it is entirely possible that the underfunding of the post office and the new postmaster general, that the trouble around the post office could lead to some difficulties in November with the delivery of mail-in ballots. And so it's a huge deal. I'm not quite sure what can be done about it, though. That may be a space in which the president has a lot of room. He appoints the postmaster general. It seems to me he has more direct control over that than his recent threat to issue an executive order to try to regulate mail-in voting. Okay. But with the post office, he has a lot of power in that space.
Yeah, my friend Paul just commented, amen to more coverage of this. And it is, if Erwin brought this up, we're going to be voting in a pandemic. There's just no two ways about it. If you look at I'm not an epidemiologist. If you look at the trend lines, we're not going to be back to quote unquote normal on November 3rd. And so what's the safest way to vote? It's voting by mail, but that requires a bunch of infrastructure before and a bunch of infrastructure after. And, the front end and the back end both require the postal service. That's the one thing that they have in common.
And that infrastructure hasn't been funded either. The first CARES Act allocated $400 million for elections when it probably take a billion or two to bring us up to where we need to be for November.
And if I could put this together with what we said earlier, imagine that the ballots aren't delivered by the Postal Service in time or won't be delivered back to be counted in time. What a federal court should be able to do is say, we'll extend the time for turning in your ballot in order to deal with the delays by the Postal Service. But Republican National Committee versus Democratic National Committee said the federal judge there couldn't extend the time for turning in the absentee ballots because federal courts can't change those rules before the election. So combine delays with the Postal Service with federal courts not being able to solve the problem, and you can really see where the crisis will happen in November.
Yeah, I think I speak for a lot of us when I say we are back in fetal position. Let's end with this question. Erwin, I'm going to direct this to you. It's from Brianna. And the question essentially boils down to, this may be a dumb question, but why are arguments about whether or not you like the Electoral College, why do they boil down to seemingly if you're a Republican or if you're a Democrat? Now, part of the answer, of course, is which states the Electoral College tends.
Yeah. I think it's a little bit more complicated. I think Republicans at this moment favor the Electoral College because in 2000 and 2016, a Republican candidate who lost the popular vote became president because of the Electoral College. Interestingly, had Ohio gone for John Kerry in 2004, Kerry would have won in the Electoral College while losing the popular vote. Had that happened, our perspective based on political party might be very different. But there is something structural. Small states are tremendously benefited by the Electoral College. I'd end my remarks with the map that you put on at the beginning. If you look at the big states like New York and Illinois and California, they're all right now blue. But so many of the red states the small states are red. And so Republicans perceive that they benefit from the Electoral College, and Democrats perceive they're more likely to lose because of the Electoral College, which would happen in 2000 and 2016.
All right. Erwin and Franita, it's been terrifically depressing, but so fun at the same time. I've really, really loved talking with you. You were far and away our first choices to have this conversation, and I feel so grateful that we could have it with you. I'm going to end with essentially how I always end, but this time actually more than ever, which is if you are in a state where you need to request a ballot, please do that early. If you're in a state where they are going to mail the ballot, please feel very comfortable using that. Don't feel that there is systemic corruption or voter fraud in our system. This is me talking. It's not the Hammer talking. It's not Loyola talking. And when you get that ballot, for all the reasons we just talked about, there's no reason to delay. There's no reason to wait and hope that that ballot is going to get to the right place in time. And please do weigh in, take part in our government. It is a good thing when our representatives truly represent us and not a small sliver that we call a voting class. So with that, thank you, all of you, for being part of these Hammer Forums. Erwin and Franita, thank you so much. I learned a lot. I'm going to cry later off camera, but no, it was a great conversation. I really appreciate it. With that, Hammer Forum, please play us away. And feel free to click leave meeting.